All right. Hi, guys. Thank you so much for joining us on this estate planning webinar. My name is Tabitha Justice. Tell you a little bit about me before we get started, and then we'll move on to our guest. So my name is Tabitha Justice. I am the owner of Just Us Retirement and also of Bringing Back the Village, which is an advocacy group for those that are 55 and older. Rachel and Brian are both a member of Bring Back the Village. I have one daughter and four cats, and I am a continual student, which is a great opportunity for me tonight because I get to learn about estate planning from our two guests. So they're going to teach me as well as teaching you as this goes along. Just to give you a little bit of information before we get started, Just Us Retirement is the one hosting this event tonight with our guest. We are a Medicare and retirement company, over a decade of experience in the business, and we are what's considered collaborative and education-focused company, which means we partner with lots and lots of different organizations in order to help our clients in the best way possible to fill in the gaps between wealth and health. So we have office locations in Charleston, Hayes Valley, Point Pleasant, and Parkersburg, and we're also available for Zoom meetings, team meetings, or meetings. So now we're going to go into our guest. Brian Schad, you are our first guest. Would you like to introduce yourself?
Sure. So I'm Brian. I'm a certified financial planner and also something called a certified divorce financial analyst. So I work with a lot of people going through or recently have gone through a divorce. I feel like I live out of a suitcase most of the time, but I go between. I've got a place in Pittsburgh. I also spend a lot of time in Morgantown, as well as Charleston and Hayes Valley and Elkins. So I kind of bounce around between those locations based on, I guess, what day of the week it is. I work with a private wealth management firm based out of Pittsburgh, working with clients all around the country, really all 50 states. It's crazy what we can do on Zoom today. And it's not all in person, even though it's nice to see people in person as well. And really, I help people make the best financial decisions and spend and enjoy the most money with their families. So, today we're going to focus on some different estate planning type things, but really anything, retirement, financial, insurance, if it has to do with money, it's probably in my wheelhouse.
And Brian, I want to touch on this just a little bit. Can you kind of briefly explain, because I know someone's going to have this question, what
Sure.
the difference is between a certified financial planner and a financial planner?
You mean a financial advisor?
Yes.
Yeah. So a lot of people are familiar with the term financial advisor, but I bet if I asked 10 different people here, what does a financial advisor do? I'd probably get 10 different answers.
Mm-hmm.
Most of the time, a traditional advisor just kind of focuses on one little thing. So they may just do like some investments, or they may just kind of do some retirement accounts for somebody. They may do some insurance, and that's kind of like their wheelhouse, but they're generally a little bit more, I don't want to say basic, but a little more kind of entry level per se. A certified financial planner, or at least a good one, really are looking at all these different elements of someone's financial life, their estate planning, their tax planning, their investment planning, their legacy planning, their business planning. And they're helping clients make decisions with the end in mind and thinking about those other elements as well. So a lot of people don't think about how, talking about your life insurance may have a big deal also with your tax planning.
Right.
So putting all those together essentially is what a certified financial planner does, on top of the normal things an advisor does.
Perfect. Thank you. And now we're going to go to Rachel. Rachel, would you like to introduce yourself?
Sure. Hi, my name is Rachel Carrico. I'm an attorney. I practice in Charleston, West Virginia, but I also practice all over the state of West Virginia. It seems lately more so, but that's great. I love to travel, and I do home visits with people because I know a lot of my clients, as an elder law attorney, they can't get out to see me. So there is a big part of my practice that does do house calls. Elder law is a very specific area of law. A lot of people don't realize that. A lot of attorneys kind of on the side will do wills, and they'll do power of attorney documents. That is not advised because wills are actually very, very customized and are very individualized to people's estate planning desires and their goals. Same with those power of attorney documents. So, an elder law attorney, you can't say that you specialize in it because there are no law specialties like doctors. We're not allowed to say that, but that is the primary focus of my practice: estate planning and elder law. And elder law, as an elder law attorney, you have to know about property laws. You have to know a little bit about tax law. You have to know about Medicaid. You have to know about Medicare. So it's got a lot of different reaches. And so if, you got to look for an attorney that's a member of NALA, which is the National Academy of Elder Law Attorneys, because you have to become a member of that. You have to specialize or focus on elder law to be a member of that. And that's really important. I am a mom, and I have parents that are still alive and are very much a part of my life. And I recognize the issues that they face.
Yeah.
And, I also recognize at my age, people that fall into that category of having children in high school or even younger, young adult children, and then also aging parents. It's that sandwich. That's that period of your life where you're sandwiched in between taking care of both. It can be really stressful. So I really like to help people who are dealing with those issues as well. I have kind of a funny sense of humor. So I try to really keep estate planning and these elder law issues light. What's life if you can't laugh at yourself and, the challenges that you face sometimes. So, which is where Good Grief Law came from. I didn't want it to be, Last Wishes Law or something dark and gloomy. Let's make it funny. Good grief. Here I am dealing with this. And I also really try to encourage people to, live their life. Don't think that you've got to save all this money, forever and not spend it. You want to invest it. You want to make sure you're covered for your long-term care needs, but you also want to make sure you're going to enjoy life.
I'm so glad that you explained the difference between an elder law attorney and a regular attorney doing wills, because I've seen that a lot myself. So Thank you, Rachel. All right. So we are first. The agenda for today, and you guys are going to teach me about this, is the importance of having an estate planning strategy in place, estate tax laws, 3 major risks to your legacy, special circumstances, and how to get started. So I'm very excited for this. All right. Why do I need an estate planning strategy? Rachel, I'm going to start with you. Would you like to start with this one?
Sure. Yeah. So estate planning, a lot of people think it's for the rich and for the dead. And I say that all the time. Estate planning also encompasses how you're going to age, and age safely and age comfortably and according to how you want to age. So estate planning includes who's going to make decisions for you. Estate planning also reaches back all the way into when you first are starting out with a family, when you first start owning a home. A lot of people don't even think they have any need at all for estate planning until they're in their 60s, 70s, 80s. However, that will that you have, that is where you make the determination who is going to be the guardian of your children if something were to happen to you and your spouse. So that is a very important aspect that a lot of people overlook. And so that, to me, there is different levels of estate planning, but the most basic level needs to start as early as when you first start having assets and you start having a family.
All right. Thank you. Brian, anything you want to say about this?
Yeah, I love, Rachel, what you said about the different levels, because I just think that's so true. And a lot of the people that I work with, I hear two things very frequently. Normally in like an introduction meeting, I always ask, like, when was the last time you updated your will? And 80% of the time it's, I don't have a will. And that's for any person at any age, essentially. So there's different levels. A lot of people think estate planning is this complex. I've just sold 4 businesses and I've got $100 million here, there. And, they think trust funds and yes, that is a thing and that is real. And those are things that we do, but it's not just for those people, the call it everyday Joe or whatever you want to call it. There's a basic level that everyone needs to be completing. And I think there's been a real lack of education where a lot of people just don't understand that. So Rachel, I really appreciate that. And I can resonate with that a lot.
And I will tell you, I always start with the most basic plan that I think will meet my clients' goals. So, a lot of attorneys, will jump in and say, let's talk about a trust. Let's, everyone, and sometimes people come to me, my friend got a trust, I need a trust. I will tell you this.
I hear that all the time.
95% of my clients do not need a trust. They are great for very specific circumstances. They're fabulous. And they're needed, but most people don't. And so a very basic estate plan that minimizes the family conflict, that's your will. What you want to have happen to your things when you pass, you've got to have a will if you want to make those decisions. So, there are like, and I tell everybody there's 4, and we'll get into it later, but there's just really 4 very basic documents that people need for estate planning. 2 of those I do for free. So
There we
come
go.
into it knowing that.
All right. I love that. And I love, again, the pointing out that so many people have a misconception on what estate planning is. So, Okay. Estate tax laws.
Now let's put them all to sleep right out of the gate.
Yeah, right.
Let's make them glaze over and fall asleep right now.
I'll jump into it and try to keep things, to the point and not get us where we hear any, people's eyes closing. But essentially a couple things. So, right now the top income tax rate is 37%. Now that's federal rates. There's also other things there, or like if you're getting into that territory, there's, Medicare surplus tax and some other things. But to keep it simple, that's the highest rate today, which historically is very low.
Okay.
The highest rate ever was, I'm going to screw this up, but I believe it was back in the 50s, 60s. The highest marginal federal tax rate at one point was 91%.
Wow.
Yeah. And the average over the last 100 years, which it's been a little more than 100 years, federal taxes were supposed to be temporary. So temporary that we're, having this conversation today. The average high end of tax rates has been 60%. So that's been the average. And then for estate purposes, there's something that's called the federal gift and estate tax exemption, which a lot of people will refer to this as the death tax, if you've heard of that before, which essentially is a tax that your heirs will pay when you pass away. But right now that you have to have a really, really high net worth. If you're married, it's over 27 million today. That number is, yeah. So it's, hopefully if you're having that conversation, that's a pretty good conversation to have.
Yeah.
And Rachel, I know there's some things changing there that I'll let you chime in on.
Okay. So I will say this. Most people don't have to worry about federal estate taxes right now. So if you are single, if your estate exceeds $13.6 million, you will pay that very, very high tax rate on everything in your estate that is over $13.6 million. If you're married, that doubles. because you can pass your exemption on to your surviving spouse. So if you're married and you die, your spouse, unless your estate is over $27 million, you're not going to pay any federal estate taxes. West Virginia does not have any estate taxes.
Oh.
So a lot of people don't realize that. So, you know, a lot of times people will come to me, I need a trust because I need to protect myself from these estate taxes or protect my estate from estate taxes. Unless you're in that category where your estate is worth over $13.6 million right now, that is not a consideration for you. Now, that number is expected to sunset in January of 2026. It's expected to go down to around 5 or 6 million.
Wow.
Right. So if you're at that point, if you're single and your estate exceeds 5 or 6, whatever that number is, which we don't know at this point, if it exceeds that number, then your estate will be taxed at a tax rate, you know, wherever you fall. So that might be a great time if you already have an estate plan. Meet with your financial advisor, your CPA, and with your elder law attorney or estate planning attorney to go over it and make sure that your estate will be protected.
And Rachel, you just made me think about something. What I see a lot of too is what you just said. There's always changes. So people need to stay with their attorney, stay with their CFP, whoever it is helping them. It's not a one-time thing. It's a relationship that you're going to have with these partners, right?
Yeah. And I always tell people, okay, you know, if you get a will and you're in your 20s or 30s, we don't need to even think about it again for 10 years, unless there's certain triggers in life, a divorce, you know, you start a new business and I have a list of those things that I say, if none of these things happen in the next 10 years, don't come and see me. Don't even call me. Now, when you're starting to get into your 30s, 40s, I'll say, all right, let's lower that a little bit. Let's just pull it out and look at it every 5 years.
Okay.
As you get older, it starts to be like, all right, let's once a year, let's just come in and check up on things. Has your health changed? Have you gone into an assisted living facility? You know, as your spouse passed away. So, you know, again, your estate planning evolves. And so, but if you start early, it's really easy to just do a little update.
Wonderful. And this next slide, it's a lot of the same information, but I wanted to go over this because Rachel, you and I were talking about that 1800, how people misconstrue that sometimes when it comes to the Medicaid.
Yeah, and if Brian wants to add to this, I won't go into a lot of detail about that, but so you can give somebody $18,000 a year and not report that on as a gift, you know, as a gift on your IRS tax report. $18,000 per donor per recipient. So you can give 5 people $18,000 a year and not have to report it. Okay. But where that becomes a problem when people come to me is they say, okay, I'm getting older, but I might be in a nursing facility in the next 2 or 3 years. I'm going to start giving those gifts. I'm going to start doing that $18,000 to all my grandchildren so I can get rid of all my money. Medicaid will still penalize you. That there's a 5-year look back. And if you all of a sudden start giving away giant gifts of money up to 8, you know, even if it's $2,000, $3,000, whatever it is, and certainly $18,000 is going to draw their attention, you may very well be penalized by Medicaid for eligibility.
All right.
And I'll jump in real quick because I think this could potentially help maybe even just one person on this call. One thing I see a lot is people as they get older, again, they start to try to gift things to their heirs and their family. In all likelihood, you do not want to gift stocks and bonds that are not in a retirement account, and you don't want to gift property because there's something called the step up in basis rule. And it really applies to anything that's considered a capital asset, which no one here is supposed to know what that really means. We can help you with that. But when you pass away, as long as they are listed as the beneficiary, those assets immediately go to the beneficiary directly with no tax. But if you gift them and you bought a property for 100,000 and now it's worth 500, you can run into some issues. You especially run into issues with stocks because it's easier to report and track. If you've invested 10 grand into a stock and now you're gifting that stock that's worth 100, well, now your heirs are going to pay capital gains tax on the growth, where if you just left it to them via beneficiary designation, it would go immediately with no tax.
Okay, so I think we have some examples of that coming up that will be interesting.
Perfect.
This is some of it. All right, which of you two want to tackle this one?
Brian, sounds like it's right up your alley.
This is you, Brian.
Yeah, so charitable donations, political donations, are certain things that they're always exempt from taxes that are considered gifts.
Okay.
There's more intense things. There's things called donor advised funds, different ways that you can essentially give and be tax intelligent, I'll call it.
Okay.
You want to make sure you understand the rules, because I like how right on the screen, spousal gifts, assuming spouse is a U.S. citizen, you'd be surprised how many little tiny things can throw these rules off where you would not qualify. There's definitely allowances for education, medical expenses. So there's big ticket things that you can definitely gift money to and have some tax benefits to it per se. But you just got to be really careful because there's always a lot of fine print with this kind of stuff.
Perfect. Thank you. Oh, here we go. Step up in cost basis. That's all you again, Brian.
So perfect. So great example. We buy a house that's worth 220, or 200,000 back in 1990. In 2021, that house is now worth 500,000. As long as that asset has been given via the beneficiary designation or via the will, something direct that shows a direct, we're not going through probate and some other things. There is no tax on the gift or the asset that the heirs are receiving. Or if they gifted it legitimately before passing away, there could be a tax there. We generally want to leave capital assets not via gifting, but via beneficiary designation. It's much more tax efficient.
I think we actually have that example also.
There you go.
Yep. And so this one is where they are actually gifting it.
Yep. So we want to
risk. We said we're going to go over the risk to not doing estate planning. So we are on risk number 1, probate. Rachel, I think this one's you.
Okay. So if anyone has ever probated a loved one's estate, then you probably have PTSD. It is a really stressful, kind of complicated process. West Virginia has tried very hard to pass some laws, the small estate affidavit. That's, if somebody has less than $100,000 worth of property, and less than, I can't remember the number. I think it's $50,000 in financial assets. You can just do this, small estate affidavit that just says that I'm not going to do formal probate. This is what they have. I promise to pay their debts, the legally enforceable debts, and to pass out what's left of their estate to their beneficiaries. Okay. That's a little bit easier than formal probate. So a lot of times people have a lot of things that go through probate. Homes have to be sold. Cars have to be sold. You've got to find all the heirs at law. Even if they have a will, a lot of people don't realize that. You still have to list all their heirs at law on that. So a lot of times finding them and getting their addresses so that the probate department can send out notification. You've got to have the original will. A lot of times, if someone doesn't have a will, you have to post a bond as executor to cover the value of their estate. And that's and the amount whether you get that bond and what that, bond rate is going to depend on your credit. So there's just a lot of things that people really don't anticipate when it comes to probate. So, most people do have to go through probate, but you can go through a very simple probate process if someone's done a great estate plan, or you can make it a nightmare for your loved ones, which I really do not encourage. That can really cause a lot of people a lot of stress.
Yep. Brian, you good with this one?
No, that's perfect. I have nothing to add.
Okay. We kind of just went through this, but we went through how to avoid it. Do you want to go through the steps of probate for us, Rachel?
I'll do it very quickly. It starts with turning in the original will, and you can probate an estate with a copy of a will. It's much more complicated. And it's not uncommon that people come to me, I know my mom had a will, we can't find it. In West Virginia, you cannot turn in your will to the probate office before you die. So you have to keep possession of it. Wow. As an attorney, I don't keep people's original wills. I do keep a copy of them, but I don't keep the original. That goes home with you. A lot of people lock those up in safes. They hide them. Nobody has the combination to the safe, and to get into the safe. You can't do that until you're the executor. So it really can be something. So you've got to turn in the original. Then you become appointed as administrator of the estate. You post a bond unless it says in the will that you do not have to. Another great benefit of having a will, you don't require your administrator to have a bond. And I'm going to use the word executor and administrator interchangeably.
Okay.
Then the executor or administrator has to do an appraisal of the estate. That means you have to figure out what assets are probate assets, what are non-probate assets. You got to figure that out. And most people do this without an attorney, which it's a lot. And that's a lot of times you have to just sort through mail. You've got to go through drawers. You've got to make phone calls just to figure out what assets they actually had. Then once that's done, you have to go through a creditor period. It's usually 60 days where creditors can come forward and make claims on probate assets of the estate. Once those come in, you kind of pay those off in order. There's a specific order in our statutes that say who gets paid first. Once all that's done, then you can start distributing the assets to the family members.
Okay. So not an easy process.
No. And this is true. It's costly. It is extraordinarily time consuming. Mm-hmm. Family members will start, wearing you down. When are we getting our inheritance? When are we getting it? Where are we getting it? They also are public record. So the will and the probate assets are part of the public record. That's one thing about a trust. It keeps things out of the public record. And the person who serves as the administrator or the executor is in the role of a fiduciary. You have a legal duty to not do this wrong or mishandle money. And so I do represent a lot of people who sue executors and administrators and powers of attorney because they have violated their fiduciary duty. So that's another little stressful part of it.
Mm-hmm.
Brian, anything you want to add to this?
No, she's hitting the nail on the head. It's something that's not fun. So that's the beginning. My unofficial non-attorney answer is it is not fun.
Okay, so how can we avoid or minimize probate? I feel like both of you two can say something on this one.
I'll jump in first. So please, I'm going to say it, please, 2 more times, please have a beneficiary listed on your life insurance, as well as all of your other accounts. Make sure those beneficiaries have been updated. Make sure your ex-wife, if you don't want her there, is not still listed. Funny, but happens much more often than you would think.
Yes.
So all of these things, please have beneficiaries, because essentially if we have a beneficiary listed, we can essentially avoid the probate process with certain assets. And then I'll let you, Rachel, jump to the trusts and some other things. But that's the number one thing that I have to say.
Okay. And what Brian just said, naming these POD, pay on death beneficiaries, that is part of estate planning. So, your life insurance, if you've named somebody that is not living at the time that you pass, then that money will go into your estate. If you name someone, you can name POD beneficiaries on a bank account, on a checking account, and you can name pay on death beneficiaries for your home. That's called a transfer on death deed. It works the same as a life insurance beneficiary, a bank account beneficiary. These are people who have absolutely no rights or interests in your asset up until the moment that you pass away. And at that point in time, what they need to do is just take that death certificate to that financial institution, and that goes outside of probate. It's great. So all those assets are avoided of going through probate, which means technically kind of means your creditors cannot go against them. So your creditors could go and try to collect assets that go outside of probate if they were very aggressive and motivated, but it's a complex process, and most of them just do not do it. Mm-hmm. So that's one thing that you can do to avoid creditors taking away part of your estate. The transfer on death deed on your property. So if you own your home, you can say, upon my death, it's a deed that is created, which is separate than your regular deed. It's filed with the clerk. It has to be filed before you pass away. And it says, upon my death, my daughter, Jane Doe, will be the owner of this property. She gets it. But until then, you can sell it, you can rent it, you can do whatever you want, and it would just become irrelevant. That filed transfer on death deed would just become null and void. And then when you pass, what they do is they just take your death certificate and they go down to the tax office, property tax office, and say, I need the property tax to be sent to me now. And it's done. Simple.
So I have a question that one of you two can answer. Isn't it also true that if you have a beneficiary on the life insurance, annuities, things like that, that is private? That doesn't become public then, right? Is that correct?
That's correct.
Okay.
Right. Exactly.
And trusts, just real quick, trusts are also private, and they also are outside of probate.
Yep. So just a couple quick ways that people can make things private if they want to make it private.
Correct.
All right. So risk number 2 of not doing estate planning, incapacity with financial decisions. All right. Who's taking this one?
Well, this to me, when I go around the community or I meet with clients, of course, a will is important for family peace and, would make things easier on your family, but you're dead. So it's not going to affect you that much, but it will affect how your legacy continues on.
Yeah.
What does have a significant impact on you and decisions in your life is that financial power of attorney, which is also called a durable power of attorney. So I cannot emphasize enough how everybody, no matter what value of an estate that you have or what your assets are, you have got to have that financial power of attorney in place. Because if you don't, and something happens to you and you lose capacity, somebody has to pay your bills. Somebody has to get you into a facility. Somebody has to get you medical care. And if they can't touch your assets, that's a problem. So with that financial power of attorney, they could, if you don't have one, they're going to have to go to court. They're going to have to do a conservatorship proceeding. And that's very costly. It's time consuming. It's stressful. And then you have to do reportings every year. I do them all the time. That is a major part of my practice is guardianship and conservatorship proceedings. But those can really be avoided with a really good and not an online, I copied off my friends, durable power of attorney, because they're very powerful. And you may not want it to be as powerful as some of them are. You may want it to be a little less powerful. And you really want to talk to an attorney to talk about who is the best person to be in that position. It may not be who you think it is.
Yeah, I love that. All right. Number 3, incapacity with medical decisions. I feel like we're back to you, Rachel.
Medical power of attorney, I do them for free. as part of the estate plan, because everybody needs one. If you don't have one, you go to the hospital, you're incapacitated. The first family member that's related to you by marriage or blood that walks through the door, okay, we're picking you. You're the medical surrogate.
That's scary.
And that usually stays with that facility. Medical powers of attorney, we put them up into a database that's statewide. And so no matter what facility you end up in, those doctors or nurses or staff at that facility can pull up your medical power of attorney. You've already picked who's going to make your medical decisions for you. Hopefully you've had a conversation with that person about what you would want. And it's all nice and neat.
Perfect. Okay, 3 important considerations. So these are the next topics we're going to go into: healthcare decisions, financial decisions, end of life care. We'll get both of you in on this one.
Yes.
Ryan, I feel like you're first here.
Yes.
Yeah. So one of the things that's important is, and this is really something to start thinking about right around age 50. So 50 years old for me is when we start to like really, maybe we're thinking about it earlier because of our parents and our family, but that's when we start to really act on it, is really being prepared for the cost of long-term care and having a plan for long-term care. So a long-term care plan is critical. And what long-term care is essentially an assisted living facility, a nursing home, an in-home health care. Essentially you can't fully take care of yourself anymore, which I'm sure a lot of people on this, I've seen with their parents or their friends' parents, and it's a very common thing. It's very, very expensive. It's the number one destroyer of wealth for retirees. It took you 40 years to build up that 401k, in those retirement accounts, build that business. It took 1.5 years to destroy all of it. So it's unbelievably expensive. The costs are rising. So you have to have a plan for long-term care that is a part of your retirement plan. If you have not addressed that, then your retirement plan has a gap that needs to be filled.
Yeah, and I want to jump in on this one on a really common myth. I wish I could scream this one from the rooftops. Medicare is not going to pay for your long-term care. People just automatically assume that long-term care is covered by Medicare, and that is 100% a myth. And most people don't find out until they go to the hospital. They're told to go into long-term care, and then they're like, oh, you have to pay $5,000 for your mom to stay in long-term care. And people are like, no, I have Medicare.
Yeah, for the first month.
Yeah.
Yeah, that's for 30 days. At basic, it's not like that's for the year.
Yeah. So,
and I think in my practice, that's one of the things that really hit people like a wall.
Yeah.
Absolutely no understanding or appreciation of how expensive it is. And a lot of my clients end up, their children have to pay for their, long-term care, which is just a huge strain on the family. So you really, the responsible thing for your family is to have something in place so it doesn't fall on them. And there's some creative solutions. A lot of people just, oh, I can't afford that. Well, can you afford $5,000 a month when you're on a fixed income?
yeah.
It is worth, and a lot of people traditionally stayed away from long-term care insurance because they were use it or lose it, and they were really, really expensive. There are some products on the market now, and Brian is great at telling people about these products that are not like that. Yes, they might be pricey, but they also have some benefits. Like there might be, beneficiary part of it. Yeah. Like almost like life insurance. So
Sure.
It's worth the consultation to find out
Yes.
what you can afford and what really sounds good to you.
Right. And I know we're going to talk a little bit about that, I think, in a bit. But the last thing I want to chime in on, because this is one of those things that just irks me as a planner, is the amount of people that don't have a plan for long-term care, but are putting $100 a month to their grandkids or their kids' college funds, have no idea the damage they're doing. because they think they're helping their kids out by saving money for kids' future college, but they have no plan or savings for long-term care. And the kids, like you said, Rachel, are going to be the ones that have to step in, and they're going to end up spending way more money on your long-term care costs than you helped with college. And it's not even close. So most people, when we actually have that conversation, we look at the numbers and we see it, it's that aha moment of, oh my gosh, what am I doing? But until you see it, a lot of people think that they're helping, and there's just such a big gap that they just don't realize there's future pain on the way.
Yeah, I completely agree with that one. Financial risk. All right, this is probably going to go back to you, Rachel, right?
This just goes back to that, not having that durable power of attorney in place. So if you don't have it, anyone, any interested party can come forward and file a conservatorship and guardianship over you. And even though you as an alleged protected person, somebody who's lacking in capacity, you will have an attorney assigned to you. But at that point, you may not really be able to communicate very well your preferences. So you've got this total stranger who's doing their best to kind of figure out you and what you would want and what's in your best interest. And then you have maybe competing parties to think that I'm the best person to be your conservative guardian. You know, I'm dad's favorite. I'm mom's favorite, even though I've never had a job, you know. And the bottom line is the court is going to make that decision. And that is, I wouldn't want that.
Mm-hmm.
Yeah, lots of fights there. End of life care considerations. So Brian, this is going to go back to you again, talking about long-term care.
Sure.
Okay. Well, I think I accidentally skipped a slide. There we go. Talk about that.
Right. So I'll be quick. Or quickish. So a lot of people think long-term care and they go, oh, well, Medicaid will pay for that. So again, Rachel,
Medicaid might, Medicare won't.
Yeah. So here's a real quick, because again, some of these conversations are deeper than we can get in a webinar. But
Right.
What I want to share is, if anyone here has ever been inside a Medicaid long-term care facility, you probably don't want to spend too much time there. It's not nice. It's not well taken care of. There's a reason that Medicaid in the state is paying for it. If they pay for it, which is a whole nother conversation. But there's a very big difference in the quality of like a real long-term care facility versus the Medicaid. And I just think that's something that a lot of people aren't aware of. And that's essentially what I wanted to share with there.
All right, Rachel, anything you want to pop in there?
Just about the medical preferences very quickly. You know, one of the documents that I do include, one of the, four of the four that I recommend is a living will. And that kind of falls under medical preferences. That really comes down to just what you personally would want. Do you want to have something in writing that says, if I lose, I no longer can use my brain, my body's still alive, but, I really don't have much going on up here at all, and I'm not coming back from it. You can have something in writing that says, I only want comfort measures. Or you can not have a living will and have a really strong, emotionally, tied in person with you that could make that decision on your behalf. So that's just one of those things that you either need to have that conversation with somebody who's your medical power of attorney, or you need to have that information in a living will.
Now, I know whenever I refer people to talk to you two about this, I always encourage, the hardest thing often for the children is trying to figure out, what did mom want me to do? How did mom want this?
Yes.
And it takes so much guilt off the shoulders if they have it planned, and then you don't have to say, like, I hope this is what mom wanted, but it's like, this is hard for me, but this is what mom wanted.
Right.
Yeah. So, all right. Incapacitation. So we kind of already went over these.
So.
anything you guys want to jump in with or recap?
The only thing I would say to that is, I personally, I want a say
Mm-hmm.
in how I'm cared for.
Mm-hmm.
If I become incapacitated, not only do I want a say in it, I don't, like you said, I don't want my children to
Mhm.
have to struggle with, I don't know what to do. If I have that stuff in place, I've made that decision. That's in writing, and all they need to do is just follow through with it. So
Mhm.
that's all I'll say to that.
Sure.
Yeah, I think anyone who's been a caregiver knows that is so hard trying to guess this is what I could have done. It just adds a lot of guilt on top of stress.
Yeah.
Okay, we're back to you, Brian. Long-term care insurance.
Sure. So one of the key ways that you can prepare for long-term care is by acquiring long-term care insurance. And there's essentially two main types of long-term care insurance plans. There is traditional long-term care insurance, and then there's something called hybrid long-term care insurance. Okay. This is generally between ages 50 to 70 is when you're getting this. The earlier, the better. And all the premiums are based on your age and on your health. Okay. Traditional long-term care insurance is very similar to term life insurance, if you've ever had that.
Mhm.
You pay money every month. If you ever need long-term care or assisted living or anything like that, they're going to pay you a monthly benefit to cover those costs. Pretty cut and dry. A lot of people don't love this just because, like Rachel said, if it's use it or lose it. If you don't end up needing long-term care, which we all hope that we don't, then all that money is gone, and that's probably hundreds of thousands of dollars over someone's retirement years.
Mhm.
Also, these premiums are not fixed. So the insurance company can raise your premium every single year, which has been happening. And a lot of people don't like the idea that their premiums can change whenever they want. So about 10 years ago, they created something called hybrid long-term care insurance, which has become much, much, much more popular. The negative is it's a higher monthly premium. Okay, so it's a higher premium than traditional. But people tend to gravitate towards these because it guarantees your money is going to be spent by you in one of three different ways. Either A, you need long-term care, and it's the same thing as traditional long-term care insurance. If you need to go to a nursing home, they're going to pay you a monthly benefit to cover the costs. Two, these have a life insurance component, or if you don't use the long-term care, a life insurance death benefit is left tax-free to either your spouse or your kid, the church, or whoever you choose. And three, they have what's called a cash value savings component, where the premiums that you actually pay, they're actually more like a deposit, and your money's actually getting saved and accumulating in this account. And you can essentially spend this money whenever you want. So it is not for when you die. It is not for if you need long-term care. There's nothing that says that 10 years from now, I can't withdraw $50,000 and go buy a boat.
Okay.
So it gives you control of the money. The negative is you have to have the cash flow to handle the monthly or annual premiums. But
Mhm.
most people actually profit off of these. If you do this at age 60 and you're age 85, most people have actually received more in cash value than they've paid in premiums.
All right. Thank you. All right. Durable power of attorney. Rachel, we're back to you on this one.
Well, yeah, this is a really, 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 really important document. I cannot emphasize it enough.
Mhm.
What I see often are people will come to me and I always say when I meet with them and they have a parent who has had a stroke or dementia, Alzheimer's, they're getting exploited sometimes. Maybe they're on the beginning stages of dementia, Alzheimer's, and they've become victimized because they've lost the ability to recognize scammers. That's just a breakdown in the brain. A lot of people get really frustrated and angry with their parents because, like, how could they not know? This was so obvious. Well, because something's going on in their brain and they can't. So my question always is, do they have a durable power of attorney in place? And oftentimes people say, yes, they do. And then what they show me is a medical power of attorney. It's completely different. It's very, very different than a financial power of attorney. Under that medical power of attorney, you cannot make any financial decisions. It's just strictly on care. And then I've seen many people bring me ones they've gotten offline, and they have not checked the right boxes, or they've checked all the boxes, and then somebody who's the agent has taken off with their money, so there's different ways to draft them. They can be done as immediate power of attorney or what's called a springing power of attorney. I generally recommend immediate, but in many situations where someone's single, they don't have someone really close to them, sometimes the springing is the appropriate way to go. So it's one of those documents that some of them can have unlimited powers. If they're immediate and it's one of those ones that have all the powers in it, they can change the beneficiary on your life insurance policy with it. So I would never have someone sign one of those without meeting with an attorney who understands them.
Can you explain what a springing is? Springing
works like a medical power of attorney, meaning it springs into action with an event, such as a doctor signing an evaluation that says this individual lacks capacity. Okay, so it springs into effect with the finding of incapacitation.
Okay,
those aren't. I don't like those very much because I've had working with a lot of doctors.
Oh, okay.
A doctor will be very quick to find you incapacitated if you are incoherent, if you are knocked out, completely out of it. If you are having good days and bad days with dementia or Alzheimer's, but your bad days are really, really bad days, but the doctor, you say, Doc, you've got to do this evaluation for my mom because I have a springing power of attorney and I need it to spring into effect because mom's getting exploited. A lot of doctors just don't want to put themselves out on that line, and it's frustrating. And then sometimes we actually have to go through a conservatorship to get it.
That's really good. That's interesting to know.
Well, and on the slide, important to note, because a lot of people don't know this, it ends when someone dies. So just because a lot of people keep acting, they, when that person passes away, the ability to handle their finances then passes on to their administrator or executor.
Okay. All right. Healthcare power of attorney, which is what you were talking about, right? Medical versus durable.
Right. Those are very simple. There is do not resuscitate language in a medical power of attorney. However, emergency personnel are required to perform all life sustaining measures on you unless you have a DNR ordered by a doctor.
Okay.
So that language in there, the do not resuscitate, that is when you have lost all brain activity. It does not apply to somebody who's at home dying of a terminal illness, whose heart stops. So a DNR, just understand, a DNR order that you get from your doctor is different than a medical power of attorney.
Okay. That's important to know. Living will. See, I feel like a lot of people get all this confused. They think it's the same thing.
Well, because they're named wrong. I mean, a durable power of attorney should be called a financial power of attorney. Right. A living will should be called my end of life directives. I don't know who came up with these names and why we still continue using them. They're confusing. This stuff is confusing enough as it is. A living will is, like I said, it's just one of those things that say, if I lose brain capacity, if I have no brain activity or very minimal brain activity, and there's very minimal likelihood it will ever come back, I only want comfort measures. I don't want my body to be kept alive on machines. That is what a living will is.
Yeah, that name does not
No,
reflect.
no, it drives me crazy.
Risk number 4, asset distribution. I feel like this kind of goes to both of you guys. So I don't know who wants to tackle it first.
Yeah, I can kind of jump and again, I'm going to sound like a broken record, but it's making sure your beneficiaries are done correctly, making having all these documents and all these things done. A good estate plan is going to make sure that what you think is going to happen does happen. The amount of people that I've seen bring me these documents in an initial planning conversation where we're getting all the info and they've got a will from LegalZoom, and then we send it over to Rachel and whoever is going to look at it, because I'm not an attorney, and they think one thing's going to happen, but actually they set up something completely different. And a lot of times attorneys do this because, as Rachel said, they're not attorneys that specialize or do this. A lot of general attorneys will do this and then they do it wrong, and then no one has any idea. So I think just having a good estate plan gives you the confidence of knowing that money is going to go where you expect it to go.
And one thing about asset distribution that bothers me a lot is a lot of people just assume a lot of what's going to happen with their estate. I don't need a will. Everything's going to go to my wife. Everything's going to go to my kids. We have very specific laws on these things. We have intestate distribution, which is coming up, I think, in another slide. But if you do not have a will, West Virginia makes you one. And it basically only follows your bloodline. It kind of starts splitting apart if you have a spouse and kids from a previous marriage, and it gets a little bit complicated. But if you have someone in your life, particularly like same-sex couples that decide that they just don't want to get married, or maybe in some places they can't, which is tragic. But if you have that very special person in your life, and maybe you're estranged from other family members, guess what? If you don't have a will and you pass away, those estranged family members are going to get everything, and that very special person in your life will get nothing. If you have stepchildren that you are very close to, that you've raised as your own children, but not actually ever adopted, if you don't have a will, they're left out. So you really, and this kind of ties into back to that durable power of attorney. You can do Medicaid asset protection planning with that durable power of attorney so that your money will pass to your heirs and not go spending down away month after month in a nursing facility. Just throwing that in there.
And Rachel, I know just from my position, I mean, we've had at least 3-4 people this year that have made an appointment with you that they have certain of these papers done by an attorney that doesn't specialize in it. And when they get to you, it is not at all what they think they have, right?
Yeah. And it's sometimes it's very subtle. It's just one little thing that's off that keeps you from doing the things that you actually want to do. So, that's why I like to know, what are your goals? So let's get this crafted so that it can meet your goals.
Yeah. Okay. Common asset distribution methods. Who wants to tackle this one first? This is probably going to be you, Rachel.
Yeah. So we talked about intestacy. The state of West Virginia will say how your stuff's going to be distributed if you have not made that designation in a will. You have your will, which will be all your probate assets will go according to your will. You have your pay on death beneficiaries, that will be outside of the will, but those will go to the people that you name to receive those assets. This is the revocable living trust. I love revocable living trusts, but they just aren't necessary for everybody, and they're significantly more expensive than a basic will. And a lot of people don't know this. You can have testamentary trusts. This is going to really complicate things, but you can build a trust into your will that you don't have to do anything at all prior to your death. And then when you die, your executor can set up a trust. I do these a lot for people who have children who have credit problems, drug problems, spouse problems. They don't like their child's spouse, and so they don't want all that inheritance to go to their child because, their spouse is going to do something terrible. So in your will, you can set up a testamentary trust that says, okay, when I die, all my kids are going to get their money in equal shares, but Joe's money is going to go into a trust. I'm going to name a trustee. He's going to distribute it. And then that trustee can give Joe money as that trustee deems appropriate, or how I've said he should get it. And that way the creditors can't touch it. Because if someone gets it in bulk sum right when you die and they have creditors, guess what? Creditors are going to get the money. So you want to set up, but you can also do a revocable living trust. It's just something that you move your assets into prior to your passing. While you're living, you are the grantor, you are the trustee, you are the beneficiary. When you pass away, it becomes irrevocable, and then you'll have terms about how your money is to go, how your estate will go to those beneficiaries after you pass. So those are fun. Those can be highly customized. But the good thing is they don't go through probate, and you continue to control your money even after you've passed away. Irrevocable living trusts are really mostly for Medicaid asset protection planning. Those have to be done 5 years before you go into a nursing home, or else causes all kinds of problems for Medicaid eligibility. And you cannot control the assets in there once it's in there. You've passed control over to somebody else.
So the important thing from this slide is there's many different ways to do it, but they need to meet with a professional and learn it.
Yeah.
Okay. This word has came up several times. So do you want to explain it just in depth one more time?
Simply, intestacy is you have died without a will.
Okay.
Your stuff has to go somewhere. And the state of West Virginia says, here's who gets it.
All right. Thank you. All right. Advantages and disadvantages of a will.
Well, I think everybody kind of needs, everyone needs a will. There's one client I met with not too long ago, and I said, Miss So-and-so, I've always said everyone needs a will. And now I'm going to say everyone needs a will except Miss X, because there is a rare occasion when someone really just does not need one. But that's a whole nother thing. But the main things is you get to decide how people get your stuff. In the residuary clause, it's a net that catches everything that does not have a pay on death beneficiary. And inevitably somebody has something that gets missed. Okay. So to keep from fighting, you want to have that will. So it keeps down the family conflict. You can state in your will who your executor is going to be. So the person who handles your estate when you pass, and you can always put in there that person does not have to pay a bond. So that family member is not put through the process of having to get bonded. If you have that language in there, and you can designate who becomes the guardian of your children. Those are all good things. All good things. The disadvantages are if you have not really done a well-planned estate plan, it can get quite complex.
Okay. All right. Advantages and disadvantages of a living trust.
Okay. Well, like I said, it avoids probate. So when you have a trust, all that stuff will stay in your trust even after you pass, and none of that has to go through probate. That's great. A lot of people love that about it. Another advantage is that you get to control the distribution of your assets even after you pass away. Okay. So, if you have children who've got issues, you can do that. But they are so customized. There are a lot of fun things that you can do with them. They're usually pretty complex. They're usually about 25 pages long. You have to name a trustee. You have to usually name a trust protector. They're really mostly for people who have higher assets or blended families. That's another thing. If you have a lot of vacation properties or just properties out of state, that's another advantage of having a trust. The disadvantages, they are complex. They are generally kind of expensive. And a big thing is most people forget to fund them. So they'll come to me and I'll create this very beautiful 25-page trust. It's customized to them. It's so great. It wasn't that long ago, somebody came in and said, we have a trust. We paid this attorney, X amount of dollars, which was a lot, 10 years ago. So, what do we do now? And
Yeah.
I'll say, well, what of your assets are named in the ownership of the trust? And they look at me like, what? I said, well, what assets have you moved into the ownership of the trust? None. So a lot of people forget or just never go through the steps of renaming their assets into the trust. So you have paid a lot of money for basically a piece of paper.
All right. Thank you for that. Now, I feel like this is a really long one. Do you want to go into this one?
We might put people to sleep. I would say just if you're considering a trust, meet with an estate planning attorney. I think that's the best thing to say about it.
Great answer. Great answer.
Okay, so we are winding down now, just a little bit more to go over. And Brian, this one's definitely you.
Yeah, so I'm going to go a little quick, and I know there's some questions here, but I don't think we're going to be able to get to them today.
Yeah. If anyone leaves a question, we've already gone over. So we promise we will get back to you. Keep putting your questions down, and then we will reach out to you to answer those questions.
Okay, so part of estate planning is your business exit planning. Same thing. Any business owner always says, I'm going to do this. I'm not there yet. It's always kick the can down the road. We normally want to start thinking about this really a solid 10 to 15 years before we're considering exiting, because there's so many things you can do ahead of time that need to happen. If you have partners, buy-sell agreements that are funded, planning strategies on how we're going to sell to a third party, how are we going to sell and keep it within the business, keep it within the family. There's so much there. People kick the can down the road. They have a lot of regrets. Make sure that if you're a business owner, you're speaking with, people, CFP, attorneys, CPA. And this is a group, guys. It's not a CPA or a CFP. You're meeting with the attorney, the CPA, the CFP. We're all working together as a team. And if your professionals aren't working together and communicating as a team, there could potentially be some inefficiencies in your plan. So I'll leave it at that, and we can move on because I know we're already over here.
Who would have thought we'd go over?
Right?
Remarriage. Oh, I'm going to actually throw this one back to you, Brian.
Yeah, so I deal with this a lot as a divorce financial analyst. First thing that comes back to me, and I'm going to just hammer off some thoughts, is one, adjust your beneficiaries. I'm going to say it 100 times because a lot of people don't do it and they leave exes and people there. Make sure that we've got a plan and you understand how assets are left from a legacy perspective. A lot of people don't really grasp what's going to go to their kids versus kids from a previous marriage. Well, how does all this work with surviving spouses? There's a lot of things that go to it. Rather than me just trying to explain it all, I'm going to give the answer of, speak to a professional. It's not as cut and dry as people may think. You have to have a plan in place to make sure everything goes the way you want it to go.
Yeah. Rachel, is there anything you want to quickly say, or do you want us to go
Just
on?
very quickly, that later in life, second marriage or third marriage, when you have adult children and you have a parent with a lot of assets, boy, can that cause tremendous family stress and division. So I think that's really important to have a good estate plan in place if you are in that situation.
Agreed. Okay, special needs. Wow, this is so important. I know both of you two can talk about this. So,
yeah, I'll jump in quick. So this is personal to me because my younger sister is special needs. So I've lived this and dealt with this through my family. There's very particular planning that needs to be done, and there's very specific. There's definitely some tax advantages and tax strategies and some protection strategies. So there's things called special needs trusts that can protect and make sure that Medicaid continues to pay if they're receiving benefits.
Mhm.
And you want to make sure that, again, everything works the way you think it does from a guardianship standpoint, from an asset standpoint. Right now we had an issue with a client that the grandmother never changed the beneficiary from the disabled child to the special needs trust. And they left the child $20,000, which ended up just going straight to Medicaid because the child was receiving Medicaid benefits, and they paused their benefits because they can't own more than $2,000 in a bank account. So there's a lot more to that, but make sure you have a plan because there's so many little things here.
Yeah. Rachel, anything you want to throw in?
Only that I do help a lot of clients who end up in that exact same situation that Brian mentioned. A grandparent leaves money to a special needs grandchild, and that money doesn't end up going the way the grandparents thought it was going to go. There are things you can do to protect it so that Medicaid doesn't get it all, but it needs to be done very quickly. So, and I do a lot of guardianships and conservatorships for young adults. So if you have a child that has special needs and then they turn into an adult, there are a lot of reasons that people have to go through conservatorship and guardianship to get in that position over that adult child.
Yeah. Okay, so we are now at the end of it, how to get started with estate planning. So throughout this session, something has popped up, and it should be popped up right now to where you guys can book an appointment. So as I said, we are what's considered a collaborative company. So we partner together, we share resources. And by clicking on the link, it is going to send you to the Just Us retirement booking session. There are places on there to where you can specifically request a meeting with Rachel, a meeting with Brian, long-term care discussions, Medicare. Click as many of those as you want, and then we will be reaching out to you to help you book your appointment with them. We will make sure you get to where you want to go. And the key takeaway from this is it really is important. I know you two emphasized it a lot, but it really is important. Don't just get those documents off of someone else or going to Google and typing in, searching for things. Really do take the time to get a custom plan. Brian and Rachel are both available to help with this. Before we finish, and I'll let you guys say any final thoughts, this is our legal disclaimer that we have to say. Just Us Retirement Solutions. I am not a certified financial planner. I am not an attorney. I'm not offering legal advice. The two of them have come on as guest speakers to help us tackle this issue together. Is there anything that you guys want to finish up with? Well, any final thoughts?
I will just start by saying that, this is like the inner workings of a clock, particularly when, you're dealing with issues for 55 and over. These things are not in a vacuum. Like, I have to work with, that's why I love Bringing Back the Village, and I love Just Us, and I love, all Brian's company. We all work together. A client will come to me, and inevitably they have an issue that Brian needs to address, or they have an issue that Tabitha needs to address. So, and we all trust one another. We all work together. We're very easy to get in touch with. I will say very briefly about estate planning. In one meeting, 45 minutes to an hour, I can have lined up exactly what you need that meets your goals. And then you come back one time and you sign those documents and you are done. It is that simple. It's not a convoluted, complex process. It can be done in one meeting and one signing. You're all set.
Yeah. And what I would say is I see a lot of people have products. Very few people have a plan.
Yeah.
So making sure everything works together, leading with planning first, and letting the strategies dictate what products and what things you acquire may be a better decision than buying products first and then being backed into a strategy.
Yeah, I couldn't agree more with that. I want to thank you guys so much for helping us out tonight. And we look forward to meeting everyone again. I can see a lot of questions. We're aware that there is no surprise.
I almost answered one and I said it was too long. We can't do it.
Yeah, so we will reach out to every single person that left a message. And I want to thank you guys again for spending time with us, for both of you two and everyone watching. And we hope you enjoy the rest of your evening. Thank you.
Thank you.
See you guys.